R versus Gladue from 1999, case summary for the foundational law exam from the NCA. Issue in this particular case as to whether the aboriginal status of the offender would operate as a mitigating factor in their manslaughter conviction. Here's the background. The accused was an Aboriginal woman. She pled guilty to manslaughter for the killing of her common-law husband and was sentenced to 3 years imprisonment. She believed that they had been engaged in sexual activity. When the accused and the victim returned to their townhouse, they started to quarrel. During the argument, the accused confronted the victim with his infidelity, and he told her that she was fat and ugly, not as good as the others. A few minutes later, the victim fled their home. The accused ran toward him with a large knife and stabbed him in the chest. There was also evidence indicating that she had stabbed the victim on the arm before he left the townhouse. At the time of the stabbing, the accused had a pretty high blood alcohol content. At the sentencing hearing, the judge took into account several mitigating factors. The accused was a young mother, and apart from an impaired driving conviction, she had no criminal record. Her family was supportive, and while she was on bail, she had attended alcohol abuse counseling and upgraded her education. The accused was provoked by the victim's insulting behavior and remarks, another mitigating factor. At the time of the offense, the accused had a hyperthyroid condition, which caused her to overreact to emotional situations. The accused showed some signs of remorse and entered a plea of guilty, and the sentencing judge also identified several aggravating circumstances. The accused had stabbed the deceased twice, the second time after he had fled in an attempt to escape. From the remarks she made before and after the stabbing, it was clear that the accused intended to harm the victim. Further, she was not afraid of the victim. She was the actual aggressor here. Okay, so the judge considered that the principles of denunciation and general deterrence must play a role in the present circumstances, even though specific deterrence was not required. He also indicated that the sentence should take into account the need to rehabilitate the accused. The judge decided that a suspended sentence or a conditional sentence of imprisonment was not appropriate in this case. He noted there were no special circumstances arising from the Aboriginal status of the accused and the victim that he should take into consideration. Both were living in an urban area off reserve and not within the Aboriginal community as such. This is what the sentencing judge had determined. And that judge also concluded that the offense was a very serious one, for which the appropriate sentence was 3 years imprisonment. On appeal, the majority of the Court of Appeal dismissed the accused appeal of her sentence. The rule extracted here, but also from section 718.2e, is in sentencing an Aboriginal offender, the judge must consider A, the unique systemic or background factors which may have played a part in bringing the particular Aboriginal offender before the courts, and B, the types of sentencing procedures and sanctions which may be appropriate in the circumstances for the offender because of his or her particular Aboriginal heritage or connection. The analysis here, if there is no alternative to incarceration, the length of the term must be carefully considered. The jail term for an Aboriginal offender may in some circumstances be less than the term imposed on a non-Aboriginal offender for the same offense. However, section 718.2 subsection E is not to be taken as a means of automatically reducing the prison sentence of Aboriginal offenders, nor should it be assumed that an offender is receiving a more lenient sentence simply because incarceration is not imposed. It is also unreasonable to assume that Aboriginal peoples do not believe in the importance of traditional sentencing goals such as deterrence, denunciation, and separation where warranted. In this context, generally, the more serious and violent the crime, the more likely it will be as a practical matter that the terms of imprisonment will be the same for similar offenses and offenders, whether the offender is Aboriginal or non-Aboriginal. Furthermore, Section 718.2e applies to all Aboriginal persons wherever they may reside, whether on or off reserve, in a large city or a rural area. In defining the relevant Aboriginal community for the purpose of achieving an effective sentence, the term community must be defined broadly so as to include any network of support and interaction that might be available, including one in an urban center. So in this case, the Supreme Court is holding that the sentencing judge may have erred in limiting the application of Section 718.2, subsection E, to the circumstances of Aboriginal offenders living in rural areas or on reserve. Moreover, this trial judge does not appear to have considered the systemic or background factors which may have influenced the accused to engage in criminal conduct, or the possibly distinct conception of sentencing held by the accused, by the victim's family, and by the community. The majority of the Court of Appeal, in dismissing the accused appeal, also did not appear to have considered many of the relevant factors. And so the Supreme Court says, although in most cases such errors would be sufficient to justify sending the matter back for a new sentencing hearing, in this case, in these circumstances, it would not be in the interests of justice to order a new hearing in order to canvass the accused circumstances as an Aboriginal offender, because both the sentencing judge and all members of the Court of Appeal acknowledged that the offense was a particularly serious one. For that offense by this offender, a sentence of 3 years imprisonment was not unreasonable, and so this appeal was dismissed. Thank you for watching my video. Please do me a big favor and hit that like button and subscribe to get more videos on law school and NCA exam prep.